2, 1.
The Honorable Court of Appeals of Tennessee is in session.
Good afternoon. Mr. Perry, we understand you have difficulty with your camera and you're just going to be presenting your argument over audio. Is that correct?
That is correct, Your Honor.
Okay, that'll be just fine, sir. If you would call the case, please.
Francisco Sanchez versus Arthur Perry III.
Mr. Perry, you may continue. You may start.
Thank you. Good morning, Your Honor. Your Honor, I'm a little nervous.
That's fine. Nothing to be nervous about.
Okay. I met Francisco Sanchez in January 2014 at a Habitat for Humanity outlet store. Mr. Sanchez was dressed in painter's clothes when I approached him and asked if he needed additional paintwork. He said yes. I identified myself as a general contractor, and I asked him if he could use additional paintwork. He said yes again. I asked him to provide me with the tax ID form, certificate of insurance mailed directly from his insurance company to our company, copy of a business license, and 3 references that he had done that year. After receiving those appropriate documents, Francisco Sanchez was placed on our list of paint contractors. Francisco Sanchez successfully bidded and completed 3 jobs in 2014 that totaled a little over $6,000. I have had hundreds of conversations with Mr. Sanchez, some at my office, some at luncheons, some at company dinners, and on numerous job sites. Mr. Sanchez and I have never needed an interpreter or translator to articulate our conversations. Francisco Sanchez called me in February 2018 and asked if I had something he could bid on. I told him yes. I told him I was doing a residential remodel and that there were some things in there he could do. Francisco Sanchez came by my office and picked up a copy of a signed contract I had. Perry Arthur III Construction Company, LLC, and T&T Real Estate Investors, which related to the job discussion that we had had over the phone about the renovation project that he could help with. Mr. Sanchez visited the job site and called me back to identify 7 selected items from that contract that Perry Construction and Mr. Tate with T&T Real Estate. Mr. Sanchez picked up and had all of the applicable line items priced individually in that contract. Mr. Sanchez returned in 2 days with the contract that I had with Perry Construction had with T&T Real Investors had agreed to. Mr. Sanchez chose 7 of the line items from that contract that he wanted to bid that was in the scope and specifications. Mr. Sanchez picked up at 16, picked up a contract for 1,600 Foster between Arthur Perry III Construction and Francisco on March 1st, 2018, that indicated those items that Francisco wished to do. I met with Mr. Sanchez at the job site on March 10th, 2018, and we both signed the contract for construction services. The contract we signed that day in March was dated May 10, 2018 by mistake. Mr. Sanchez and Arthur Perry both signed the contract dated April 10th, 2018, another mistake. We just didn't get our dates right. The contract Arthur Perry and Francisco signed was a 5-page document. We used this contract many times over the years with Francisco. The contract total for line items selected less 20% was $18,000. The 20% was the general contractor's overhead and profit. The $18,000 was paid in full with 5 checks, rental equipment costs, and material costs charged against that contract. Francisco was given a contract to select items. From those items, general contractor asked for 20%, and Francisco had 80% to do his labor and materials, and et cetera, to make money. That was the deal. That's what the contract says. Mr. Sanchez did not manage his costs very well at all. Mr. Sanchez had to buy $605 worth of electrical equipment twice because he installed non-approved material and had to tear out most of the electrical work and redo it. It had to be redone. He didn't redo it. I had it redone by a licensed contractor. Mr. Sanchez did not use a licensed electrician, and Perry Construction had to hire an additional subcontractor to finish the electrical services at a cost of $800 that was charged against Mr. Sanchez's contract. Contractor also paid $550 for cabinets in the kitchen and bath that was charged against Mr. Sanchez's contract. General contractor paid $800 for tile and carpet charged against Mr. Sanchez's contract. Those items that Mr. Sanchez did not purchase. This project ran 91 days over the scheduled base time allotted in the contract. The general contractor had to help with some of the work due to the slow progress. There were weeks that passed and Mr. Sanchez was not there, and there was no work going on at that address. Phone calls were made. It was as if the project was deserted for weeks at a time. Very slow pace there in getting this work out. The charge that Mr. Sanchez makes, that he was only responsible for labor, is not what the contract states. The contract specifically states 80% was to cover everything. Labor, material, equipment cost. What's his number? That charge of labor only is simply absolutely, positively, unequivocally untrue. The contract agreement was with Perry Arthur III Construction Company, LLC, and not Arthur Perry III Construction or Arthur Perry III. The material facts was undisputed in the motion for summary judgment. The contractor has a signed contract that states in detail for the work to be done, the cost of the work, the payments that were made, and at which times the payments were to be made. And the contract was signed by both Francisco Sanchez and Arthur Perry, appellant and appellee, before any draws were made or any checks was written. This office had a copy of a signed contract. I asked this court to forward all tax and applicable costs to Francisco appellee, and further, we seek punitive damages if applicable.
Anything further, Mr. Perry?
That's all I have, Your Honor.
Okay. We appreciate your argument this afternoon. And the way the process works, and you may already know this, but I'll tell you just to be sure, is we will take your appeal under advisement, and then we will issue a written decision, sending our decision to both sides at the same time. So thank you again for your argument this afternoon. Ms. Dempsey, if you'll recess court until our next scheduled case.
Thank you.
This honorable court is in recess until 2 p.m.
Have a good afternoon, Mr. Perry.
Thank you.